Tom asked me to visit with you for about 5 minutes to explain the Oregon law on adjudication. It'd probably be easier to explain the KBRA to you in 5 minutes. I want to say, first of all, I'm not an attorney. I don't claim to be an attorney. I'm just a country veterinarian with a passion for defending agricultural water rights. Beneficial use is the basis, the measure, and the limit of all rights, all water rights. Any use that has been designated by law to have a special value to the public is considered a beneficial use. And at this time, there are 11 different beneficial uses of water categories. That would be irrigation, domestic use like your home well, your garden, lawn, domestic livestock watering. Municipal uses, power development, public recreation, protection of fish and game, fire protection, mining, industrial resources, navigational, and my personal favorite, scenic attractions. The hydrologic cycle dictates the relatively constant amount of water that's available in a watershed or a basin. Like probably Beatty has somewhere around 14 inches of precipitation a year. Some years there are more, some years there's less. You get over into the Po Valley area, we're about 12 there. But the fact of the matter is, that's all the water that is going to be available for surface water use. That's the limit. So unless we enhance the supply of water by storage or by reduction of wetland evapotranspiration, for instance, juniper mitigation, aquifer recharge, and we're not going to have more water than that to divide. So unless we enhance the supply, each new beneficial use diminishes the value of the established water rights. In the last few decades, we have expanded wetland and refuge water use. We've expanded in-stream flows. We've expanded water for fish and game habitat. We've expended a great deal of water on endangered species demands. Expanded flows for water quality improvement. And expanded flows for scenic beauty. All of these demands diminish the value of existing water rights. If you think of that supply of water as a pie, and if you had 4 beneficial uses and divided it equally, you would have 4 pieces of pie. The size of the pie doesn't change. But if you have 8 beneficial uses, each piece of pie becomes half of that size. If you have 12, it becomes 1/3 that size. So as we create more beneficial uses, we diminish the value of the current water rights. We diminish the value of the current beneficial uses. In 2009, the Oregon legislature decreed that all the water in the state of Oregon belongs to the people, to the public. That is codified in Oregon Revised Statute 537.110. The water cannot be owned by the public. Only the right to use the water can be used by the public or by appropriators. If you think of it as an easement, you may have an easement to cross your neighbor's land to get to your pump, for instance, or to your head gate. That easement does not give you ownership of that property. It gives you the right to use that property for a specific purpose, to cross it to get to the pump or the head gate. You can't go on that property and go fishing or go hunting or camp or build a cabin. It's not your property. You just have the right to cross it. With a water right, you have the right to use the water for the beneficial use that is applied for in the permit, but you don't own the water itself. Oregon water law is entirely based on the doctrine of prior appropriation. First in use, first in right. The first to divert the water or to leave it in stream with a right for a beneficial use owns the right so long as the water is continuously used for that purpose without waste. The first in priority has the right to use their entire water right before the second in priority has the right to use any of their water. You think of it as a chest of drawers with a top priority right. You would use all the water to fill that drawer within that person's water right before the second drawer owner receives any water at all. Then the second drawer gets to fill their drawer, the owner of the second drawer, so to speak, gets to fill that drawer with water up to the maximum amount of their water right before the third. That's how the doctrine of prior appropriation works. After 1909, an individual had to apply for a permit to divert surface water to irrigate a specific parcel of land. That was February 24th, 1909, that law was passed. The water right would then be appurtenant to the land or attached to the land to which the water right was acquired for. That permit includes a description of the point of diversion, the volume of water in acre feet, which is the duty, the flow in gallons per minute or cubic feet per second, which is the rate, and the season of use. Other conditions might be applied as well on those water right permits or certificates, such as the requirement to measure the water or perhaps to put in the fish screen. That would be examples of conditions. Since 1909, all water rights have been prioritized by the date of application, not the date when you put it to use, but the date of your application. The point of diversion, the place of use, the rate, duty, and season of use are all recorded in that permit. Once you have proved up on that permit, once you have created the point of diversion, the ditches, you've irrigated your fields, you have an engineer come out and verify that you have met the requirements of your permit, the state of Oregon will then issue a water rights certificate. And at that point in time, you own the right to use that water. Again, you don't own the water. You use the right to own the water. All that use is junior to the pre-1909 water right holders. A great deal of water was already being put to use, obviously, before that 1909 law was passed. And that's where the adjudication comes in. Adjudications are necessary to confirm the existence of pre-1909 code rights and to place them in priority with the later acquired water right code permits. The adjudication process is found in ORS 539, and it's about 10 pages long, a fairly convoluted process. The adjudication will establish in law the priority date of all pre-1909 claims and then also verify the points of diversion, the rate, duty, season of use, beneficial uses allowed, and the land that the water right is pertinent to, attached to. The owners of these pre-1909 claims must be able to document their use. They have to prove that they in fact have the right to use that water. There are 7 steps in adjudication. The first is the state will notify potential holders of vested water rights, those are the pre-1909 owners, that there's adjudication is in the works. The holders of the vested water rights then make claims for the water that they've been using. They must be able, again, to prove when they began using the water, where they've been diverting it, where their ditches were to deliver the water, the fields where they've been using it, and the crops they've been growing, and so forth. They have to be able to document all that.